morning, everyone, and welcome back to our weekly webinar series. Today, it's our episode 135, and we're discussing a very important development with respect to the recent Supreme Court judgment on Byju's. Over to Anil.
Thank you, Ankit. Welcome to 135th episode of AAA Weekly Webinar Series. The enthusiasm is continuing, even if I'm traveling, and this is really enjoyable to both of us. The subject today that we have taken is a very important and impactful judgment from Honorable Supreme Court, and that is in the case of GLAS Trust Company LLC. This is a case where the corporate debtor is Byju's. It is a brand name of Byju's, but then the name of the company is Think and Learn, and that kind of a name with Think and Learn Private Limited. Now, this judgment actually has given us a lot of a way forward with regard to the withdrawal of the CIRP under Section 12 capital A of the IBC. This is the first thing that we will discuss, and then we also have a circular from IBPI and dated 29th of October 24 regarding the use of only one portal, that is eBikre. eBikre is the portal which is now empaneled by the IBPI, and it is recommended by the IBPI, and that is what is expected from all the insolvency to use it for all liquidation sales. The third thing that we are going to discuss very briefly, because that's a very small change, that it is the latest discussion paper dated 4th of November 24 regarding the mediation, applicability of the mediation law in the IBC. Now, this judgment, which is GLAC Trust Company LLC versus Byju Ravindran. Ravindran Byju is their trade, like a family name. Ravindran is the name of the promoter, and this judgment is 23rd October 24. And this is from the Chief Justice of India. Although the Chief Justice of India just remitted the office, and the new Chief Justice of India has already been appointed. Now, this judgment actually has given a lot of way forwards and the clarity regarding the process which is required to be followed for all kind of withdrawals under Section 12 capital A of the companies of the IBC. Now, the Supreme Court, in fact, has settled two very key issues in the IBC. One issue is whether NCLT correctly invoked its inherent powers under Rule 11 to approve a settlement agreement and set aside the initiation of CIRP. Second, whether the appellant, that is a financial creditor who was not a party to the settlement between corporate debtor and the operational creditor, had the right to appeal the NCLAT decision. So this appeal was made even before the COC was constituted, even before the claim of that financial creditor was accepted. This appeal is when the committee is not constituted, this person was a claimant. So now the court, in fact, analyzed the interpretation of Section 62 of the IBC and clarified principles and procedures for withdrawal of CIRP and settling claims under the CIRP. Now, implication, to give us a preamble, the implication is very large. First of all, the IBC initially did not permit the withdrawal of the CIRP application once it was admitted, leaving limited scope for settlement post-admission. And at that time, when there was no Section 12A under IBC, At that time, it was not possible to withdraw application. So therefore, no settlement was possible originally under the IBC. Then we saw that the NCLAT and NCLT, they were using a rule 11 of the NCLT rules and NCLAT rules, that is giving powers to NCLAT, and where something is not provided in the law, and they can take a decision. Later on, Section 12A was added to the IBC to allow withdrawal post admission, but required 90% approval from the Committee of Creditors, balancing the interest of all creditors against potential misuse by individual creditors or the debtor. Later, Regulation 30 capital A was also added in the IBBI regulations, formalizing the withdrawal process, permitting withdrawals both before and after the formation of the Committee of Creditors. Now, the combination of Section 12A and Regulation 30A provides a structured, codified withdrawal process reflecting the evolution from judicial discretion to a regulated framework. So, Rule 11 is a judicial discretion, whereas the Section 12A and Regulation 30A of IBBI regulations for CIRP is a regulated framework. Now, the Honorable Supreme Court also highlighted Regulation 30A of the CIRP regulation, which outlines the procedure for withdrawal, and that was only added to cover the gap identified in the previous judgments, allowing withdrawal applications both before and after the constitution of Committee of Creditors. Now, the Honorable Supreme Court also emphasized that Section 12A and Regulation 30 capital A were necessary to protect the interest of all creditors, making withdrawal contingent upon broad COC consensus rather than individual preferences. So these are the primary focus of the Honorable Supreme Court judgment in this case of Byju's. Now let us actually try to see what are the facts of this case. As I said, the Think and Learn Private Limited, which is basically promoted by Byju's, and the brand name for their business of education was also as Byju's. So this was providing some kind of online educational services, and the Board of Control for Cricket in India, BCCI, Board of Control for Cricket in India, BCCI, in fact, an operational creditor, they executed a team sponsorship agreement. So Byju's entered into a team sponsorship agreement, and you could have seen about 3 years back in IPL matches, or even so there were a lot of advertisements from Byju's, and however that money was not paid to BCCI, and then another fact in this case was there was another subsidiary of the company, which is the Think and Learn Private Limited, the Byju's. That company was in America, that is Byju's Alpha Inc. That company, in fact, availed credit facility through a credit and guarantee agreement for USD 1.2 billion of loan, and where this GLAS Trust Company LLC was appointed as administrative agent. So the GLAC Trust Company LLC is a administrative agent appointed when a loan was given to the subsidiary of this Byju's in USA, that is Byju's Alpha Incorporated, and the guarantee was given by the Indian company, that is the Think and Learn Private Limited. That is the guarantee which in fact triggered. That is the guarantee in fact which was triggered, and the GLAC Trust Company, they are also called as collateral agent or administrative agent for handling this kind of loan transaction of 1.2 billion. That means about 10,000 crore. So there was a there was a proceedings going on before Delaware court in USA, where the GLAC trust enforced their security interest under the credit agreement, and that was because of their security interest, that was leading to removal of Byju's, that is the pre-existing directors, including Riju Ravindran, and appointment of a new sole director the the GLAC, by the administrative agent. Now, then the further notice of demand was also issued, invoking the uh, corporate guarantee of the corporate debtor for the entire outstanding amount. And then this in almost in July 22, this Byju's Alpha Incorporated allegedly kind of transferred whatever was left with them, envisaging that the creditors' action will come, envisaged, and 533 million US dollars, in fact, was transferred to a hedge fund in USA. When it was transferred to a hedge fund, that means whatever is left in Byju's Alpha Incorporated, that was also diverted. So therefore, a kind of a motion for a preliminary injunction to secure these funds were also filed uh, in the United States Bankruptcy Court. In the United States Bankruptcy Court, which is District of Delaware in USA, and Court, Delaware Court, in fact, issued an injunction restraining Riju Ravindran and certain other Byju's entity from spending or transferring or altering rights to this 533 million US dollars, which was transferred to a hedge fund known as Camshaft Capital Fund. Camshaft Capital Fund in 22. Now the funds moved to a non-US trust on behalf of the Inspillearn, in February 24. So all these proceedings were going on in USA, and also this Delaware court, in fact, also started contempt proceedings against Byju's, and there was a fine of about 10,000 US dollars per day that was also imposed on Riju Ravindran in case this kind of contempt will continue, and even also it was kind of perjury was also started. When in India, now let us talk about the Indian insolvency proceedings. In this case, the BCCI filed an application under Section 9, and as an operational creditor, because the BCCI entered into a kind of team sponsorship agreement, and the total amount of 158 crores were due from Byju's, and that was not paid. Therefore, this application was filed. In the meantime, another application was also filed under Section 7 by the applicant, which is GLAS, in his capacity as administrative agent, because of that USA dispute. And however, the NCLT admitted the operational creditors application under Section 9 and granted a liberty to GLAC Trust that in case of any kind of agreement, any kind of withdrawal, then Section 7 application would be again revived, depending upon the subsequent developments at the appellate level. So that was the judgment given by NCLT while admitting a Section 9 application, and while saying that Section 7 application by GLAC, that would be that would be revived in case of any future developments in the appellate authority case. Now, the appeal before NCLT, in appeal before NCLT, when there were two appeals filed before NCLT, one was filed by GLAC Trust saying that this Section 7 application disposal is incorrect, while the ex promoter Riju Ravindran also made an application that Section 9 admission that is also challenged because he wanted to settle. Therefore, the settlement, in fact, a settlement was effective because 50 crore of rupees was already paid and the balance was already agreed by BCCI. So therefore, the NCLAT thought that the application which is admitted is under Section 9. 50 crore has already been paid and the balance is readily balance is payable. The BCCI has also agreed and an agreement is also settlement agreement is also signed. Therefore, NCLAT thought that the withdrawal is permissible as per the past uh, judicial pronouncements. How the GLAC trust, in fact, was saying that the payment which is being made by the ex-director that also will constitute a preferential payment to an operational creditor, which is not permissible. And the GLAC trust also raised an issue that these funds, whatever is being paid by the promoters to BCCI, basically there is the suspected round tripping the movement of funds back into India. Initially, it is the same money which was transferred to that hedge fund. And the funds which actually were given to Baiju's Alpha Inc. in USA, and that is also kind of adversely impacted by a preliminary injunction by a Delaware court. So everything was explained before NCLAT, and also at the NCLAT. However, in the very first few hearings, they have also given an interim stay for non-constitution of the COC. So, what was the status at NCLT? There was a stay on the constitution of COC, and the after the hearing of GLAC and Ravindran, the settlement agreement was completed, and the it was withdrawn. Now, the appellant, which is the GLAC appellant, said to NCLAT that there are section 12A and there are regulation 30A. And when these two specifically regulations and the framework is available, then Rule 11 should not be used. That's what was argued by GLAC Trust before the Honorable NCLAT. Also, the inherent powers of NCLAT that should be rarely used as per the various judicial pronouncements that probably was presented by GLAC. NCLAT should not use the inherent power, discretionary powers under Rule 11, because the directors of the CD are in fact fugitives. The directors of the CD are fugitives, and the government dues are also in default, and enforcement directorate activities and also proceedings and investigations are also going on. There is an existing lookout notices against them. So all this was mentioned, that the promoters are fugitives, the government dues are also in default, enforcement directors proceedings are going on, they are also on lookout, and the significant devaluation of the corporate debtor has already taken place. It's about more than 40,000 crore that this company has taken, and this company is up to like kind of cheating, and up to kind of the other creditors will also get cheated. That kind of noise was also made by GLAC. So therefore, the GLAC said that the interest of all the creditors must be protected as per the original objective of the IBC. The original IBC objective should not be only recovery of one party; it should be the resolution of the overall corporate debtors position. The respondent, like the respondent means the uh, Byju's, they were saying that it is NCLT's power to permit a withdrawal, and the GLAC lacks standing, and standing means locus. It was also said that the uh, settlement is only between BCCI and the corporate debtor. GLAC is not a party to this, so they have no locus to object to this. And also, they have an opportunity to revive their Section 7 application independently. So, therefore, they were also saying that this business is continuing, the business of Byju's. Business of Byju's is continuing. There are a lot of human resources, business operations are continuing, employment problem, everything. So, finally, the decision of the NCLAT was, since the affidavit has been submitted by Riju Ravindran, the Byju's, that the funds which are being used are from their personal sale of shares. It has got nothing to do with the uh, Byju's overseas company, but that means Byju's Alpha Inc. So that kind of affidavit was given. So NCLT and NCLT also kind of relied upon earlier judgments of Honorable Supreme Court in the case of Abhishek Singh versus uh, uh, Huta Maki PPL Limited and Kamal Kumar Singh versus Dinesh Gupta, and basically where Rule 11 of NCLAT rules for settlement was validated. No, therefore, the NCLAT approved the settlement and the set aside the admission of CIRP under Section 9. Also, it stipulated that in case this particular settlement is breached, then Section 9 shall automatically be revived. Now, in the meantime, the uh, Byju's Alpha Inc. and the GLAC Trust, while this was going on before NCLAT, the GLAC Trust and Baiju Alpha also had further proceedings before the Delaware court after the NCLT order, and it was alleged there that some fraudulent payments are being made. However, that was also rejected by Delaware court. Now, this appeal before the Honorable Supreme Court, it was actually very clearly said, very clearly said that uh, see the first thing that the Supreme Court did, that the stay, like it was the kind of NCLAT order of withdrawal was stayed. NCLAT order of withdrawal of Section 9 petition or setting aside of Section 9 petition or order uh, initiating CIRP, that was uh, stayed. So that means the CIRP initiated again. In the meantime, the RP admitted the claims and constituted the committee of creditors. So then the Supreme Court finally gave an order again with the two questions, which are very large questions, whether the applicant, who is not a party to the settlement between BCCI and the corporate debtor, has locus in the proceedings before this court, number one, and number two, whether the NCLT made an error in invoking its inherent power under Rule 11 of NCLAT Rules 2016 in the presence of prescribed procedure for withdrawal of CIRP and settlement of claims between the parties. Third issue, whether without prejudice to the above, whether NCLAT adequately addressed the objections raised by the appellant while exercising its discretionary power under Rule 11 of the NCLAT Rules 2016. The Supreme Court, in fact, very clearly observed that the NCLAT should have stayed with the Constitution, should have stayed with the Constitution of COC and directed the parties to follow the procedure under Section 12A read with the Regulation 30A of CIRP regulation. That's what that's what the Supreme Court said. The NCLT should have stayed the Constitution. And then the court found that NCLAT erred in invoking its inherent power to approve the settlement without following the prescribed procedure for the withdrawal of the CIRP, which is provided in Section 12A and Regulation 30A. It also stated that the other creditors, like the appellant, had no right to be heard in the settlement case between the corporate debtor and BIC. Now, the court emphasized the following aims and objectives of the IBC. Now, the four objectives were given by the Honorable, in fact, emphasized by the Honorable Supreme Court. First, there is the consolidation of pre existing fragmented insolvency framework to eliminate parallel proceedings by various creditors. That was the first objective. Second objective was implementation of the principle of collective distribution, ensuring proportionate share for each creditor of the same class. Then the third was prevention of IBC's use as a tool for coercion and debt recovery by individual creditors. Fourth, separation of interest of the corporate debtor from those of its promoters management, preventing recalcitrant management from taking advantage of undue delays. The court, in fact, further highlighted two significant principles arising from Chapter 2 of the IBC. One, once a petition is admitted, the proceedings become in rem. Proceedings become in rem. That means the proceedings then would be against a property, not and the assets, involving all creditors as stakeholders. Management of the CD vest in the IRP and subsequent the RP, distinguishing the interests of the erstwhile management from the CD interest. Further, the court found that the appellant to be within the scope of any person. Appellant, that is GLAC trust, is in the scope of any person aggrieved and having the locus standi to institute the civil appeal. The court noted that Section 62 of the IBC does not impose a rigid locus requirement of appealing as NCLT or NCLT order, allowing any aggrieved party to appeal. In fact, the four stages of the withdrawal or settlement that was explained very clearly by Honorable Supreme Court, highlighting the various stages. The first stage was before the application is under Section 7, 9 or 10 is admitted by NCLT. So that is very clear that in that case, since the CIRP has not started, therefore the proceedings remains in personam as against in rem. It still remains in personam. That means against parties, not against property. So the proceedings will only in personam. So therefore, it can be withdrawal between the parties because the no order has yet been passed. So that is the first stage. Now, after the order is passed, initiating CIRP, then the proceedings are in rem. That means that the proceedings will be considered against the property, against the assets of the corporate debtor, and that has to be distributed against amongst the stakeholders. So therefore, involving all the concerned parties. So therefore, the NCLT must apply judicial discretion, considering all relevant factors and hearing all parties before deciding on withdrawal rather than merely approving settlement without scrutiny. Now, second stage is also very important. So far, what we have seen that if the COC is not constituted and there is a settlement, almost in all cases it has been admitted. Almost in all cases, the settlement has actually been admitted and the CIRP is quashed. Now, what exactly we should see in this observation that the NCLT must apply judicial discretion whether this withdrawal is to be permitted or not, considering all the relevant factors, and that is the interest of all the stakeholders, whether the company is solvent or insolvent, whether the company is in default in other case, against other creditors or not. So therefore, this withdrawal even before the constitution of committee of creditors will not be easy. It would be a judicial discretion. It will be a judicial discretion. So then is the third stage when the application is admitted and the COC is constituted. Then of course it is very simple that it has to be the application has to be submitted through the IRP or the IRP, and it has to be compliant to Regulation 30A, where the application is submitted in Form FA along with a bank guarantee regarding all the cost incurred so far, and 90% votes are required. And if 90% votes are given, then of course that is withdrawal. And later on, even when the application is sought to be withdrawn after the expression of interest is invited, then also it is same as the third stage, but it has to be further again added with the uh, with more reasonable reasons why the withdrawal is being done at this stage. Why not earlier? There has to be some acceptable reasons for this. So therefore, the Supreme Court said that this NCLT's order is not correct. In fact, the Supreme Court criticized NCLAT for not providing reasons for deviating from the procedure or justifying the urgency to approve the settlement without following due process. The Supreme Court directed the deposit of 158 crore, which was collected by Byju's, and that would be kept in an escrow account. So this particular judgment, in fact, has actually given a ratio that actually the ratio which is very, very clearly said, and I'm reading from the judgment, we are of the view that recourse to Rule 11 of NCLAT Rules 2016 was not warranted in the present circumstances. As noted above, inherent powers cannot be used to subvert legal provisions which exhaustively provide for a procedure. To permit the NCLAT to circumvent this detailed procedure by invoking its inherent powers under Rule 11 would run contrary to the carefully crafted procedure for withdrawal. In the impugned judgment, the NCLAT does not provide any reasons for deviating from this procedure or the urgency to approve the settlement without following the procedure. Therefore, the case presents complex issues related to multi-jurisdictional insolvency, the powers of NCLAT to approve settlements under inherent powers, and the protections offered to the creditors under the IBC has actually been undermined. Therefore, the court says that the balancing the interest of all is very, very important. So this is what Ankit we have for the Byju's judgment, and we have some other Supreme Court judgments also. But in case there are some questions at this stage, we can take if there is any judgment on if there is any question on the Byju's judgment. What we all can summarize that the withdrawal under Section 12A or Regulation 30A would not be easy. Everyone is directed not to let the company go into insolvency because withdrawal thereafter would be difficult. So therefore, one, after this order, once the CIRP is initiated, maybe under Section 9 or under Section 7, it would be difficult to withdraw. So the promoters are also guided not to wait, not to depend upon the withdrawal procedures after that, because in that case, 90% voting may be required. Yes, Ankit.
No, so it's a welcome, I think, very welcome move. We always used to academically discuss that why is it that the NCLAT or the NCLT hold any opportunity that comes by their way that the settlement is happening, and they would not look into other factors as we have seen here, whether the company is otherwise insolvent, whether there are other NPAs, whether there's other stress in the company. So these factors are not looked into presently, which would not be an ideal idea for any insolvency matter. And at the same time, this we were seeing a lot of cases where NCLAT is the place where people go and get stay, and then the whole insolvency process also takes longer and also becomes a very inefficient process. Also allows the promoter to take out a lot of assets from the company while the process is on hold at NCLAT. So we've seen all these things happening. So this is a very welcome judgment. So 12A is a process that would require then the RP, the resolution professional, to make sure the 12A reserves the right of the RP to preserve his fee. That's also taken care of there. Otherwise, in many NCLAT cases, stay cases, the and when where the cases get vacated, there's nothing provided for the fee of the RP. So that will also be taken care of in the 12-way process. And also this whole process that NCLT, okay, the first process was that for any operational creditors to issue a notice, 10 days notice. So many companies might believe from their legal counsels that, oh, this 10 days is not important. Let us not settle this debt within these 10 days, even if we can. Then the next stage comes that the NCLT is hearing that matter. Then the next stage comes that the NCLT passes the order, and then you go and kind of get it vacated. So as you said, that the whole process of settlement, if it has to happen, has to now advance these stages. It cannot happen after the NCLT has reserved the order, pronounced the order, or after the insolvency or has already started. So that wake up call at that point in time will be too late. So yes, I think a very good judgment.
Yes, I think I don't see much of the questions on this. I think we can move on to a couple of more judgments, and then we will move on to the one discussion paper and one circular, which is also the circular is very, very important. In fact, circular is very kind of it will actually increase the obligations of liquidators to a greater extent. So that circular also should be it should be discussed. But let's see, like one couple of judgments that I would like to see, because on 5th of November, on 5th of November 2024, there was a judgment from Honorable Supreme Court by the name of Noida Special Economic Zone Authority versus Manish Agarwal. Now, in this, on 5th of November, today we are on 9th, on 5th of November, in fact, the facts of the case was the Noida Special Economic Zone Authority entered into a lease agreement with Shri Bhumika International Limited for a plot at Noida SCC. This is Shri Bhumika International Limited is a corporate debtor, defaulted on lease payments. The property remained unsold, the causing financial losses. And the default CIRP started, and the valuers were appointed. The valuation of the property was about 4.25 crore. So the resolution plan, which is also about 4.5 crore, approved by the NCLT, allocated and in rupees 50 lakhs to the Noida SEZ, and therefore their claim was about 6 crores. So as against the claim of 6 crores, the Noida SCZ authority, they were only offered 50 lakhs of rupees. So dissatisfied from this, in fact, the Noida SCZ first filed an application before NCLT challenging the order for approval of the resolution plan, but the application was dismissed on the ground that the tribunal lacked jurisdiction to grant requested relief. That is what it is mentioned. Then the other thing that actually was there in the resolution plan, the applicant, which is Noida SEZ authority, they were saying that it is contrary to SEZ rules, especially those allowing exemptions from Noida SEZ dues. The valuation process is also flawed. So the RP argued IBC, and finally the questions of law was in this case by the Honorable Supreme Court whether approved resolution plan which provided a lower amount to the appellant can then claim adhere to the statutory requirement, and if the provisions of the IBC overrides the SEZ Act, particularly regarding the dues and fees within the SEZ. Now, the Supreme Court says that the Supreme Court dismissed the appeal, upholding the resolution plan and affirming that the IBC overrides SCZ Act provisions where applicable. The appellant's claim of 6 crore was denied, and the court favoring the Committee of Creditors' commercial judgment. The Honorable Court also said that the valuation is a primary question of fact and interference is generally not warranted. The Supreme Court also clarified that the uh, all dues, including statutory dues owed to government bodies not included in the resolution plan, are extinguished. So this also kind of further diluting the impact of rainbow paper judgment, because the Supreme Court has said again in this particular judgment that all dues, including statutory dues owed to government bodies not included in the resolution plan, are extinguished. So further, no further proceedings of such dues are allowed after the adjudicating authority approves the resolution plan. So this is what is the judgment. So the Noida SCZ cannot claim higher amount. The Noida SEZ would be considered as a government authority, but they would be allocating as per the uh, commercial wisdom of the committee of creditors. Now, uh, there's another judgment which is again a very recent judgment, that is in the case of Vidyasagar Prasad versus UCO Bank, and that is a judgment of dated 22nd of October 2024, where the corporate debtor availed some loans from UCO Bank and other banks for a thermal power plant, and the payment, there was a default, and NPA and Section 7 was initiated. So the company, in fact, contested this application on the grounds of limitation, alleging improper authorization for the petition and disputed the existence of the debt. The NCLT rejected the contention, suspended management, went to ANCLAT, where the appellant again undismissed. So the question which was before the Honorable Supreme Court was whether there was a valid and unequivocal acknowledgement of debt within the limitation period, thereby enabling UCO Bank to initiate CIRP proceedings. No, this is again it was actually said by the appellant that the balance sheet entries of the corporate debtor did not amount to an acknowledgement of debt. It was contended that these entries were vague and lacked specificity regarding UCO Bank's name as a creditor, thus failing to extend the limitation period. The contention, finally, the Supreme Court says that the entries in the balance sheet could constitute acknowledgement of debt. Further, the balance sheet entry and the auditor's note were sufficient to prove acknowledgement of debt. Further, the court said that the statutory balance sheet did not require the explicit listing of the creditor's name. The court also held that the OTS proposal by the corporate debtor acknowledging the debt also goes in favor of the UCO Bank. So, therefore, the limitation was not applicable in this case. Another judgment, which is in the case of COC of KSK Mahanidhi Power Company Limited versus Uttar Pradesh Power Corporation Limited and others. This judgment is dated 14th of October 2024 by Honorable Chief Justice of India, the then Chief Justice. So now in this case also the CIRP started in 19 and against the KSK Mahanadi Power Company. The creditors finally, which was assigned to Prudent ARC, filed an application seeking consolidation of the CIRP of the corporate debtor with two other companies, which was rejected. So the PNB, in fact, appealed. During the appeals pendency, two further applications were filed. Now, I will just go to the crux of this judgment, and the question that was involved in this case was whether the High Court could defer the CIRP under its jurisdiction in Article 226 after declining consolidation relief, especially when such a direction may interfere with the IBC procedure. The Supreme Court examined if High Court overstepped its jurisdiction, impacting the CIRP discipline and IBC. So the observations in this case was the Supreme Court found that the High Court had no jurisdiction. High Court had no jurisdiction to defer the CIRP under its jurisdiction in Article 226, especially after declining the main relief of consolidation. The court emphasized that such a discretion breached the discipline established by IBC. Further, the court says the High Court order is set aside, and the directing the deferment of CIRP, allowing the insolvency proceedings of KSK Mahanadi Power Company Limited to continue without an interruption. Another case, which is not very recent, but it is on 28th of August 24, which is in the name of VS Palanival versus P. Sriram CS, the liquidator. And the name of the corporate debtor is Sri Lakshmi Hotels Private Limited, and it was actually the total claim and money borrowed was 1.57 crore. Dispute was there leading to arbitration and in the before the Madras High Court, and then on the non-payment of amount, and there was arbitration award, and the financial creditor filed an application under Section 7 initiating CIRP. No resolution plan was received. The company went into liquidation. Now, the liquidator valued the company's property and scheduled an auction. After receiving no bids, a second auction was also held with the reserve price reduced by 25%. Now, this one, the purchaser, KMC Specialty Hospitals, the auction purchaser, won the auction but failed to pay the balance sale consideration within the stipulated 90 days. Failed to pay the balance consideration within the stipulated period of 90 days. And then the auction purchaser filed an application citing COVID-19. And besides taking the plea of COVID-19, one of the grounds taken by the auction purchaser for extension was that the income tax authority had also passed an order attaching the auction property. So the auction purchaser eventually paid the balance. So in this case, in fact, the observations of the court was that the auction purchaser was entitled to the benefit of the order dated 23rd of March 2020, which is a COVID order, extending limitation period due to COVID-19 pandemic. Regulation 47 capital A of the IBBI regulations for liquidation, and then the adjudicating authority acted within its jurisdiction by granting the extension. So the extension was granted, and therefore the auction purchaser to deposit additional 50 lakhs of rupees, 50% of the difference between the initial reduced reserve price with interest. So that's what is the judgment from the Honorable Supreme Court. Now, Ankit, we actually have to move to one of the very, very important circular, which is dated 29th of October 2024, which is issued by IBBI. It is regarding the centralized electronic listing and auction platform for sale of assets under liquidation process. And this will be effective from 1st of November 2024, although the word used is may. In fact, earlier in case we see Regulation 33 was amended of the liquidation process regulation, and this particular sentence was added. What was that sentence? The liquidator shall ordinarily sell the assets of the corporate debtor through an auction in the manner specified in Schedule 1. And when we go to Schedule 1, then it was also further clause 7 was saying from a date to be notified through a circular by the board, the liquidator shall sell the assets only through an electronic auction platform empaneled by the board. Now, the word used here is shall. The word used here is shall, that the liquidator shall sell the assets only through an electronic auction platform empaneled by the board. Then it is from the date of notification. Now, the notification is through a circular. So the present scenario is that there are a lot of auction platforms, and there is an information asymmetry. All these auction platforms, they will list the asset very close to the auction date. The buyers are not getting appropriate time for due diligence. So therefore, the one circular has in fact handled various difficulties. The one circular now, what is this circular? In fact, this Indian Banks Association, IBA, actually has floated a platform which is called e-Bikre. Bikre is the Hindi word of sale. So e-Bikre platform, in fact, it is operative since the last couple of years, and most of the SARFAESI assets are also being sold through this platform, which is a kind of a consortium of 12 public sector banks. They floated a new company called PSB Alliance Private Limited, And this PSB Alliance Private Limited is the company which is owning this platform, eBikre platform. It is presently selling the SARFAESI assets. Now the eBikre has already been developed. Further facilities will also come. This eBreak, actually, the eBikre platform will list all assets. So what is important? What is important is that now it is a single listing platform for all the liquidation assets. In fact, this is the same for SARFAESI assets also. Now the circular requires that the liquidator to list all assets of the corporate debtor as mentioned in the asset memorandum. Asset memorandum is prepared by the liquidator and it is submitted to the NCLT. And this asset memorandum, when it is submitted to NCLT, within 7 days of the asset memorandum submitted to NCLT, within 7 days, the liquidator has to list all the assets, may it be land or building, may it be plant and machinery, may it be equipment, may it be other assets like the financial and security assets. So all these assets are supposed to be listed on the portal immediately after the asset memorandum is submitted to NCLT. So therefore, the prospective buyer, they will have the knowledge that what kind of assets are coming for the sale, what kind of due diligence they would need. They will reach out to liquidator for the due diligence. So that is where the entire success would lie. The asset would be available for public view immediately after the asset memorandum is prepared and submitted to NCLT. The auction may take later. So all the assets would be there and everyone will go to that platform. That everyone will go to that platform. So therefore, this is a very, very important. It is also said in the circular that all the liquidators are supposed to list all unsold assets of all their liquidation cases. And if it is a new case, it has to be listed within 7 days from the preparation of asset memorandum and submission of the asset memorandum to adjudicating authority. So therefore, all the liquidators are required, number one, for their existing liquidation cases, all the assets are supposed to be listed on eBikre. For their new cases, first asset memorandum will be prepared, and then the after the asset memorandum is submitted to NCLT, within 7 days, all the asset has to be listed on this platform. Now, in this platform, in fact, this will one, that it is a centralized platform. Number two, it will actually increase the transparency and accessibility by the public at large. This will also improve the bidder participation. This will also have the operational efficiency of the insolvency professionals. So it is, in fact, uh, mandatory compliance is required from the insolvency professionals. So this is what, Ankit, is the circular. And anything that you would like to add, then I will go for a minute to the discussion paper.
No, I think this is a good step by IBBI to centralize and kind of use the same platform, which is the government platform for stressed assets. And I believe that this will help in the entire process. I will also use the opportunity to take up some questions. I think we can quickly take up some questions. So, Mr.
I will take 1 minute to
So
just
you
handle
can
this discussion
complete
paper.
that and then we can take up the question.
So this discussion paper, in fact, what I'm trying to say is the discussion paper is a very, very small discussion paper. The only one amendment is proposed, and it is proposed that regulation 2BA would be added to the uh, IBBI regulations for corporate insolvency. Uh, then regulation is that an operational creditor may undergo mediation with the corporate debtor for resolving the disputes of commercial nature in accordance with the provisions of the Mediation Act 2023 before filing application under Section 9, and thereafter file the application under Section 9 along with the report of the mediator. Now, one, that it is restricted to operational creditor. Number two, the word written here is may undergo mediation, so it is not mandatory for the time being. Three, for resolving the commercial nature disputes of commercial nature. Four, the mediator will give a report. Mediator will give a report, and that report will be added or attached to the application under Section 9. And the provisions of Mediation Act 2023 would be applicable. To my understanding, the Mediation Act 2023 is not fully implemented because the Mediation Council of India is not yet constituted. Similarly, that council will work as kind of institute like IBBI, regulating all the mediators. The mediators are not yet empaneled, so it is yet to be seen. I think everyone needs to give their uh, observations to IBBI, and the last date for giving observations is, I believe, 24th. So that is where we actually, I would like to say that this should be yes, the last date for submission of the 24th of November 2024. So what I'm saying is it is restricted to operational creditor. Number two, it is still using a word may. Number three, it is only for the commercial disputes. Number four, there will be a report of the mediator. But the entire thing is as per the Mediation Act 2023, which is not fully implemented. The Mediation Council of India is not made. The empanelment of the mediators are not happening so far. Maybe that the existing mediation law, which is the arbitration and reconciliation law, that will handle till the time this Mediation Act 2023 is not fully implemented. So that's what it is from my side. Let us take some questions, Ankit.
So first question is from Mr. MP Jindal. He says that who can apply for withdrawal of any withdrawal of the CRP process before the RP. So my understanding of 12A is that before the COC is constituted, the suspended directors can approach the RP and ask for further filing of an application for withdrawal by the RP before the NCLT. And post CRP, also post COC constitution, also the 90% voting becomes mandatory, and then that is what is required to be taken by the RP to the NCLT. Before the COC is constituted, the submission, the suspended directors can take the settlement with the settlement agreement done with the applicant before the RP for further filing before the NCLT. I think that's the process.
So the regulation 30 capital A is very clear that there will be an application form FA. Form FA is provided in the regulation, and that form FA has to be signed by the applicant. The applicant who submitted the original application under section 7 or 9, and he would be the person who would be entitled to apply for withdrawal. The promoters cannot withdraw of their own. It has to be an application in the form FA by the applicant, and that form FA will be submitted to the IRP or the RP along with the bank guarantee for all the expenditures that has been incurred or that would be incurred by the IRP or the RP till the withdrawal is concluded. So these are the minimum formalities. So without the original applicant, Form A cannot be submitted. And without submitting Form A, the IRP or the RP cannot even go to NCLT and submit the application for withdrawal.
So then there's a question from Ranjan ji, and he says that in my cases, Honorable Supreme Court and another settlement was allowed by NCLAT. CRP cost is due, although ordered by Honorable High Supreme Court, but later it was later filed application with NCLT for recording settlement and pay CRP cost. So the follow-up with NCLT is the only way out for the CRP cost to be paid by the company, even after settlement. I don't think there is any other way forward.
I think like since there is already an order and it's a little bit of follow-up, and in case somebody denies, then I think the contempt of the court can actually be some. But again, the litigation expenses will increase. The only problem is that still I feel that lot many IRP and the RPs are struggling to get their fee for the period, and especially when the stay is granted by the NCLAT and then later on it is quashed. So then the RP doesn't know who to give these fees.
Then Lalitji is saying that when CD settles with applicant just after admission of the case, as there was no public announcement, when there are other cases pending in NCLT to be heard on different dates, is this withdrawal valid by applicant through IRP? So
Now,
when
this,
so
I think, Ankit, this particular paragraph that I read, it was very clear in that paragraph that even the application for withdrawal is submitted before the constitution of COC. It is the duty of the adjudicating authority to see whether this withdrawal should be permitted or not, looking into the interest of all the creditors, all the stakeholders.
yeah.
So, in case there are other applications pending before the adjudicating authority, then the adjudicating authority can always say that this kind of withdrawal is not permitted. Yes, okay.
then
Supreme Court said very clearly in this case.
then we have Anchuji. Anchuji is asking that can we. So there is a request to discuss the Jet Airways judgment and the circular on real estate next week. That's one.
No, we'll
Then
do that. We'll do that.
then Santoshji is asking that if mediation award is given in favor of OC, why he will file Section 9 application after mediation award. So such mediation award, how will that mediation award be enforced? So mediation is a process in which both the parties have to agree to something, and that is what a mediation order or the so the mediation order either from the mediator can be that I tried mediation, there was no mediation, and therefore back to the court. Alternatively, the mediation order can say that I mediated and these were the commitments that the parties agreed into, and this is how they will act. So, the idea is that if mediation happens prior to the filing, there is a possibility of the matter not going to court anyways. I think that's the idea.
Yes, absolutely. That is the idea. In case the mediation is successful, then no such application. But in case the mediation fails, there has to be a report from the mediator, and that report uh, from the mediator will be the part of the application where the mediator will say that he tried, but it was not solved.
Yeah. Then Naresh is saying that whether COC can review its resolution after approving resolution plan before approval of same by NCLT. I think
See, the COC
question
can review. COC can review in case it is not approved by the committee of credit. In case it is not approved by the
NCLT.
adjudicating authority, but there has to be some justification for this kind of review.
Then we have if the bidder includes the properties of the personal guarantors as part of the resolution plan and proposes extinguishment of the personal guarantees, which is approved by COC, whether the NCLT would approve the said resolution plan. So there is a possibility after some amendments in the regulations where the resolution plan can talk about how to deal with personal guarantees. It can also club those assets as part of the entire proposal as long as those creditors are party to the entire process with whom those individual assets are also mortgaged or who might have a lien on those assets. So a combined resolution plan is possible legally, right?
Yes, in some cases, I think in one or two cases it has happened where the like it is kind of inseparable assets. The land is owned by the promoters, and the building is owned by the company, and machinery is owned by the company, or even a slightly different case. So then the NCLAT had given an order that all these assets, in case mortgaged to the creditors, they can collectively can be sold in liquidation process. However, the uh, in the case of a resolution plan, the only difficulty is that if any one person who has the personal guarantee of the promoters, and if he is not interested in uh, kind of making a joint resolution,
Extinguishing it, or making it part of the
extinguishing the personal guarantee, then he can object. But yes, technically it is possible that the personal guarantee and the personal assets are also part of the resolution plan, but only condition would be that it should be agreeable to the entire committee of creditors and nobody is objecting to this. But if there is any objection from any other person who may have given some loans to that individual, but the assets, uh, there are some people, they have given some loans to the individual, and then all the assets of that individual is clubbed together in the resolution, so they can object. Technically, yes, but practically, hardly there is any case in India where the personal assets and personal guarantees are also clubbed. Personal guarantees, yes, but hardly any case in India where the personal assets are also clubbed in the resolution plan. However, in liquidation, there is an NCLAT order.
All right. I think we are already about beyond time. So I think we should put an end to this webinar because we are already past 12:10. So thank you everyone for the immense response as always, and we were able to have a good interactive session, good evolution that is happening in the insolvency law. I think these two, three things that have happened recently are bringing more clarity and should bring better efficiency in the entire process.
Yes,
Thank
thank you
you.
very much, all the viewers. Thank you very much. It is our way of learning. Thank you.